Welcome everyone to the second of 13 in this 2025 Winter Learning Series with the Missouri River Bird Observatory. Before we begin, I would like to thank the folks that are making this series possible, and that is the David Risberg Memorial Grant of the Conservation Federation of Missouri, and also our MRBO supporters. And I know that there are some of you on here, and we thank you so much for your ongoing support of MRBO. We quite literally could not do the things that we do without you all. My name is Dana Ripper, and with me tonight from MRBO is Ethan Duke, my co-founder. Our mission is conservation via science, education, and advocacy. We study birds and their habitats in Missouri's most imperiled ecosystems. We engage thousands of people each year in over 100 education events, and we advocate for science-based conservation policies at the local, state, and sometimes national levels. So all of our webinar topics in this 13-part series, they all have direct effects on the conservation of birds and other wildlife, as well as a pretty much perfect overlap with human health and well-being. Last week, we gave more of an introduction to the organization in general and like why we're doing this series and how it relates to conservation. So if you want to check that out for a little more background information, that is on our YouTube channel, which is at Mo River Bird Obs. Or you can check out our website, mrbo.org. So we hope that these webinars will help you become more aware and involved and inspired to take action. Our presenter this evening is Bart Elmore, and I saw Dr. Elmore present as part of a very in-depth deep dive beyond plastics course called Plastics and Public Health with Megan Wolf, who's actually speaking leader in this series. And after I saw Bart present, I implored him to come present for us as well. So a little bit of background on him: a native of Atlanta, Georgia, Bart Elmore is an environmental historian who investigates the environmental impact of big businesses such as Coca-Cola, Walmart, Bank of America, FedEx, Monsanto, and more. He leads a yearly trip to the United Nations Climate Change Conference and is deeply involved in the history of climate change negotiations and climate change litigation. He is an award-winning author of 3 books: Citizen Coke, The Making of Coca-Cola Capitalism; Seed Money, Monsanto's Past and Our Food Future; and Country Capitalism, How Corporations from the American South Remade Our Economy and the Planet. In 2022, he was honored with the Dan David Prize, the world's largest history prize, dubbed by the Washington Post as a, quote, new MacArthur-style genius grant for history. He's the winner of several teaching awards, including the 2018 Alumni Distinguished Teaching Award, the highest teaching honor at Ohio State University. Bart works to ensure that environmental scholarship is accessible to a broad public, and was a Carnegie Fellow at New America, a think tank in Washington, D.C., dedicated to supporting writers whose work is focused on addressing some of the most pressing issues of our time. His work has appeared in the New York Times, the Washington Post, the Wall Street Journal, NPR's Weekend Edition, Joe Rogan's podcast, The Conversation, and other popular media outlets. In both the classroom and in public forums, Bart hopes to use history to unite people across the political aisle and across cultural divides, and hopes that in doing so we can find solutions from the past that can help us create a more ecologically sustainable economy in the decades to come. So, Dr. Elmore, please take it away, sir.
Thank you, Dana and Ethan, so much. What a pleasure it is. It's a real gift, to be honest with you, to spend these evenings talking with folks who really care deeply about the planet and ecology. And so I just am thankful to everyone who's, uh, maybe missing dinners or doing whatever just to be here to have a conversation that hopefully will be useful to you all. And that's the goal that I have. I'm hopeful that I said earlier to Dana, this is kind of like an accordion. I can kind of move this in and out as interest may show in different areas of this talk. And so we can kind of talk about the things that really matter to you. And I hope you'll use the chat feature moving forward so that if you have questions or thoughts, I'll hopefully be able to answer some of them. As I conceived of what I wanted to talk to you all about this evening, I thought, well, what's going to be the most useful thing for a group as wide ranging and with as many interests as we have in the room. The initial kind of thought, of course, was plastics, because we had met and Dana and I in a session regarding plastics. And so I thought, well, what's a new angle on that story that could be useful for folks who may not be aware of the kind of change in litigation strategies that are emerging around trying to hold accountable firms that have contributed to this massive kind of plastic problem that we have today. And so that's the objective I'll have, and I really am not sure on exactly how long the conversation will go, but I'm going to keep it tight. I will certainly not go on and on. I'll try and keep it within the 35-45 minute range so that we can have plenty of time for conversation. And the goal is to talk about kind of big business in a new era of corporate liability that has emerged as a result of kind of new litigation strategies. And you'll see here that this is a new case that has emerged that I've actually been in conversation with folks about, which is has been brought by Rob Bonta of the Attorney General's office in California, where they sued ExxonMobil, one of the larger plastics producers in the world, for deceiving the public on the recyclability of plastic products. This came out in September of 2024. I think it's a landmark case. What its future will be, obviously, I'm a historian. I'm an environmental historian, so I'm not sure exactly how this will play out, but it's certainly a novel strategy. And I think it's something for all of us to be aware of who care about how to put pressure on industries and businesses that are having an impact on our planet. So we're going to get there. We're going to talk about this later, this particular case at the very end, but it's a bit of a teaser because I want to start by talking about the history of climate change litigation, which I think is in some ways informed the case, particularly around plastic in California. And I should add a couple of things at the front. As Dana mentioned, I'm a professor of environmental history at Ohio State University. And when I went off to grad school, I didn't even know that environmental history was a thing. I was actually studying segregation and problems with Southern public schools, where I'm from, in Georgia and other states in the South, largely because I'd been a high school teacher and I'd seen some of the issues that Jim Crow had kind of created in our public school system in the South. But in my second year of graduate work, I found the field of environmental history, and I flagged this for those of you who either A, may be going back to get degrees or have kids or young people that you know that are looking to get into various lines of work that are connected to environmental issues. And Ohio State has really become one of the premier places to do environmental history. We have 14 faculty here that teach environmental history. And just to put that in perspective, there are very few departments that have 14 historians, period. So we're very lucky as one of the bigger universities in the world, really, to have a cohort of environmental historians who specialize in geographic areas around the world, from Russia to my specialty is the US. My colleague does Brazil, Jen Eaglin. We have people that do, Europe. We have people that do other parts of the world. And so for those who are interested in this type of work or in this line of thought, we would love to connect. We'd love to be there for folks who are either going off to maybe a graduate program, think of us, but more importantly, just to be there to help you think about how the past can be useful in helping us think about solving some of the biggest environmental problems we face in the future. So that's what I'm going to talk about. I'm going to use this climate change litigation history as a lens to understand, at the end, kind of this new strategy that's being developed to litigate the plastics industry, which is, to be honest with you, one and the same. As you can see here, Exxon contributing to climate change, but also the plastics issue. And you'll see my email there at the bottom. I'm certainly happy to connect with folks offline or at another time. I see my job being, someone who's paid by a public university, and I went to the University of Virginia, so my education was also publicly funded, to give back. So to the extent that you have issues and things that you want to talk about or work to explore more fully, after this talk, I'd be happy to connect over email. That's why I'll have that on the last slide as well. So, and then one other thing I'll mention, we take students to the UN Climate Summit every single year, what is known as COP, or the Conference of the Parties to the United Nations Framework Convention on Climate Change. So if there are people who have interest in the climate negotiations that just happened in Azerbaijan, well, we were there. We were also there in Dubai, and we could have conversations about kind of what's happening on the international stage, potentially as well in this conversation. So there's lots of things we could dive into depending on your interests. But let me just start by kind of diving into this story of how we even got here. It's going to be kind of our end point. Let me step back in time and let's talk a little bit about climate change litigation. And I promise you, I'm not going to have a ton of slides with a bunch of words, but I do have a few that just kind of set the tone for the larger framework of the history that's been unfolding around climate change litigation. As you'll see here, by the spring of 2024, there were over 1,760 climate change related cases in the United States. And that's pretty astounding considering the fact that when we go back to the early 2000s, there was maybe a handful of cases that anyone would consider kind of climate change litigation in the truest sense of the word. And what's remarkable about the number of cases that we're seeing is that they range across a variety of different areas of law, from constitutional law cases to public trust cases to securities fraud to statutory violations, common law, which of course is law that's not statutory, but established through precedents of courts and so forth and so on. And they've been filed and ongoing both in federal and state courts in the United States. The interesting thing to point out here is that really no other nation has come close to the United States in terms of this litigation kind of blossoming in the last several decades. The second closest country that has anything close to what the United States has is Australia, and they have about 127 cases that have been filed or ongoing beginning as of 2023. So we are really a unique case study to actually think about the jurisprudence and the kind of history of these cases. And I think one could argue that this is in part because of the frustrations, and many of you may feel this in the room, of environmentalists when it comes to getting meaningful action done inside the United States to protect fragile ecosystems and wildlife and so forth that we all care about. You can think about Congress, which has been deeply divided for many, many years, to the point that we really haven't seen a major piece of environmental legislation outside of the Inflation Reduction Act that has really taken on some of the issues that I think we'll talk about today when it comes to climate change. I think there's also been a frustration with the slowness of the pace of international negotiation. Going back to Kyoto and the failure of the United States to ratify the 1997 Kyoto Agreement that was designed to really force nations to radically reduce their greenhouse gas emissions. And we've had the Paris Accord in 2015 and some progress when it comes to international climate negotiations. But for many Americans, it's just been too slow and not fast enough, which has led to the courts. If the Congress can't fix it, the executive seems to be slow in addressing these issues, and international treaties don't seem to be doing the job. This is why we've seen this kind of flurry of litigation over the last several decades. And again, a couple slides here with just a lot of words, but they're helpful to ground you. In 2017, over 654 climate change cases had been filed in the United States federal and state courts, up from almost none a decade earlier. That's a little bit of a misnomer. There were cases coming out of the 1990s and early 2000s, but really just a handful. And by 2020, as I said, the number had risen to 1,200, and you can see that final number is ticking up even just 2 years later to 1,522. We're kind of accelerating into these cases in the last several years. Not just Australia, we have seen the United Nations begin tracking climate change cases in some 24 different jurisdictions outside the United States. And by 2022, there were approximately 658 lawsuits originating out of 65 different non-US jurisdictions. Many of these cases focused on government actors. That is to say, they're cases that are trying to force regulatory agencies to do their job better when it comes to forcing businesses to reduce their greenhouse gas emissions. But other cases have taken on much broader scopes. Some have been really kind of human rights cases, including one that occurred in the European Court of Human Rights that found in favor of several Swedish women who brought suit against the government for not doing enough to curb greenhouse gas emissions in Sweden, thereby endangering their lives. But it's really interesting to look at the larger case law because it extends not just to public agencies or even human rights cases, but they target a wide variety of businesses from automobile companies to airlines to utility firms and fossil fuel companies. For anyone really interested in this, there is a database that is available to you that the Columbia University has put together that has chronicled all the ongoing climate change litigation in various state and federal courts in the United States. And it is the Sabin Center, S-I-B-I-N. Let me put this over here instead of just yelling it at you. So you'll see it in the chat. The Sabin Center for Climate Change Litigation. It's a remarkable database for anyone interested in this kind of litigation strategy because it chronicles all the different cases that are out there. And you'll see the variety of different plaintiffs and defendants that are in these cases. Now, what's really fascinating, this is one of the last of the big wordy slides I have, is that a variety of different statutory laws and other laws have been used to try and bring suit in these cases. What may be interesting for many of you that are interested in wildlife, birds, and other things is the degree to which the Endangered Species Act has been invoked as a key statute to initiate climate change litigation. Really, the use of the Endangered Species Act in terms of climate change litigation takes off in kind of the late 2000s. And by 2020, the Endangered Species Act was the third most common form. Actually, that's a bit of a misnomer because you'll see the numbers here. It was one of the most common forms of climate change litigation because, as you can see there, state-level NEPA initiatives also have been a very, very high level of cases as well, totaling around 75 filings as of 2020. And the idea here is using the Endangered Species Act to say, look, climate change is a threat to these habitats, and to not address climate change through various mechanisms or various actions, it can endanger a particular species that needs protection or that is protected under the Endangered Species Act. Right behind those, one of the leading laws that's been used in these climate change litigations has been NEPA. This is the National Environmental Policy Act. The National Environmental Policy Act was passed in 1969 and went into effect as we moved into the 1970s. This established the rule that various institutions and agencies needed to complete an environmental impact statement before they completed any particular project. And we began to see as early as the 1990s, folks filing suit arguing that say the National Highway Transportation Safety Administration, for example, had not followed NEPA to the letter of the law by not considering climate change when approving a particular project. And we've seen that being one of the more effective ways in the courts using NEPA to try and actually bring about change by forcing an agency to be more aggressive or to change their policy or to go back and make sure that an infrastructure project doesn't have as big of a climate change impact. Not surprisingly, the Clean Air Act has also become one of the primary mechanisms through which people have initiated climate change litigation. You can see 151 cases by 2020. That is really interesting because technically it wasn't until 2007 in the case of Massachusetts versus EPA, and I'll put this in the chat for you. 2007. Thanks, Dana, for adding the URL there for the Sabin Center.
For sure. Hey, Bart, just so you know, I think you're just sending text to host and panelist.
Even better. I'll change it so it's everyone there. Thank you.
Thanks.
And then you won't have to repeat my work for you. There we go. Massachusetts versus EPA in 2007. This was the critical Supreme Court case that determined that the EPA had the authority under the Clean Air Act to regulate greenhouse gas emissions. Might be surprising to y'all because if you go think about the Clean Air Act, which we think about the real aggressive acts that were passed in the 1970s that gave the statute its real power. At that time, it was not kind of predetermined that greenhouse gas emissions were included under that regulatory authority. It took the Supreme Court in 2007 finding that, yes, in fact, greenhouse gases could be considered something that endangers the public and should be regulated under the Clean Air Act. The EPA had to do something further. It had to actually make what's called an endangerment finding. I'll put that also before it could begin regulating greenhouse gases. And if you're looking at the years, I always tell my students, do dates matter? Well, yes, if you want to know how history works, you had the Bush administration in power at that time. And the problem with that is that EPA didn't want to regulate greenhouse gas emissions coming from fossil fuel burning and so forth. So it wasn't until 2009 and Lisa Jackson, who was Obama's EPA official, who officially made that endangerment finding. The EPA saying, we can now show with scientific evidence that greenhouse gas emissions are affecting the health of communities. It is endangering public health and therefore should be regulated by the EPA. That is a pivotal moment because it means that the Clean Air Act could be litigated once that finding from the Supreme Court was made, that the EPA has this authority. And it led to a bunch of other cases after that precedent was set. There were also state level NEPA initiatives, as you can see here, 139 by 2020. Each state has its own kind of NEPA rules, and we saw a lot of things happening at the state and not just the federal level. And this was really taking off. I mean, this is a pretty remarkable change in terms of going from almost none of these cases to within a matter of a few decades, you start seeing this climate change litigation just exploding. And there's Massachusetts versus EPA. Again, it challenged to the decision by EPA not to regulate greenhouse gases from mobile sources under the Clean Air Act. And the Supreme Court found in a close decision that, yes, the EPA did have regulatory authority to regulate greenhouse gases. I should note that this also built on the Chevron precedent, which many of us are familiar with because of recent case law. This goes back to 1984. It was a case essentially in which the Supreme Court found that federal agencies had the right to essentially decide how a law should be enforced if there's some ambiguity about how best to enforce that law in the nature of the way that law was written. And that Chevron rule, of course, has recently been overturned in 2024, what's called Chevron deference, the ability for an agency to say, because this law was written somewhat in an ambiguous fashion, we are the experts who should have the authority to figure out how best to implement that law. That precedent goes back to 1984. I think it was foundational to the context of these cases in 2009 and 2007 with Massachusetts versus EPA. But now it's been undone by a recent court case, Loper Bright Enterprises versus Raimondo, which overturned that Chevron precedent in 2024. So that was kind of a setback for all this. But nevertheless, we're seeing some progress as we move out of the 2000s into the 2010s. Now, whether you knew it or not, there were some really novel litigation strategies that were emerging at the time. I've actually talked to the lawyer who actually represented Exxon, as he put it, kind of the bad guys. He has now turned on his former employers and is now working to try and promote climate change litigation. But he worked for Exxon in this particular case. This was a case involving a Kivalina, if I'm saying that correctly, a community in Alaska that essentially was watching their coastline basically be eroded as a result of climate change and the rising seas. And they filed suit against Exxon, charging that they should be pay compensation to this village for the harm done by the fossil fuels that they sold that contributed to climate change and thereby affected their homeland. And as you can imagine, this was a novel argument and therefore a really, really complicated case. And ultimately, the village was unsuccessful in this lawsuit, which goes back, as you can see here, to 2008, largely on the grounds that the court finding that it was very difficult to have what's called traceability, the ability to ensure that the oil that Exxon was selling could be traced directly to the impact this village was having. Of course, you could disagree with that, and many people would, but that's kind of the court's issue at hand here is, can we prove that this specific company's fossil fuel sales had the impact in this specific area? These are the types of legal questions and concerns that were at play in these discussions. Another thing that came up in these early cases was what's known as this displacement theory. Some judges would argue that because the Clean Air Act, now according to the Supreme Court, gives the EPA the authority to regulate greenhouse gas emissions, it's not an issue for the court to adjudicate. It is up to the EPA to actually carry out the Clean Air Act's mission. And it's the EPA's responsibility to do this, not the courts to make a decision about how this community should be compensated. So these were all really, really complex pieces of litigation. A bunch of other cases emerged. Some were federal common law cases that ultimately were not successful, with plaintiffs arguing that the effects of Exxon's fossil fuel cells, BP's fossil fuel cells, you name the oil company, has contributed to a nuisance, a public nuisance that has harmed people. Those cases at the federal level were ultimately not successful. By 2011, there was a case called AP versus Connecticut that ultimately established that federal common law cannot be used in these climate change litigations, which meant that a bunch of people started focusing on state law. Can we look at state nuisance law and litigate from state to state on these issues? Other states, actually, attorneys generals decided that they were going to focus on laws on the books within their state that focused on deception and securities fraud. What if a company says that it's actually reducing its greenhouse gas footprint, but isn't really doing that, or says that its impact on climate change is X when in fact it's Y? Can they be held accountable for their financial documents misleading their investors on these issues? So these were really, really interesting cases. And here you can see a case. This was actually when youth started getting involved. This is a young kid, Alec L., who actually led a movement in 2011 to argue that the federal government had an obligation. This is, I guess, against Gina McCarthy, the head of EPA. And the argument here is that the federal government is failing to protect the environment in ways that violates the public trust. And this was a novel argument at the time. It ultimately was not successful, but we started begin seeing kind of all these different strategies of trying to get at this, including constitutional arguments. In 2015, a group of young people actually filed a case called Juliana versus the United States, arguing that climate change and the ineffectiveness of the Obama administration and federal agencies to address climate change was essentially depriving young people of their basic rights to life, liberty, and property, because it was potentially going to affect the longevity of their lives. It was going to affect their ability to, to have the freedoms that they wanted. And so, kind of a Fifth Amendment claim. This made it out of the lower court, but ultimately was overturned at the appeals level. And the only next strategy would be to take this to the Supreme Court. But currently, given our Supreme Court, we don't know what's going to happen there. And it's unlikely that this would be a case that would find in favor of the plaintiffs, given the current makeup of the Supreme Court that we have today. Meanwhile, again, you could see attorneys general in New York, the attorney general in New York, filing a climate change case against Exxon, again, arguing that it made these material misstatements in its financial documents that misled people on the impacts of climate change. Exxon ultimately won that case, but there's a similar case that has been allowed to move forward in Massachusetts. It's unclear whether there will be a different outcome in Massachusetts regarding this kind of fraud or misstatements claims that you could argue securities kind of cases that are emerging in these states. And two more, and then we'll turn to the plastics, and then I'll be done, and we can have a Q&A. While all this has been happening, you may have seen in the news that there has been a real effort to say, okay, look, if the federal constitutional cases have not worked out, what if we focus on states that have language in their state constitutions that say that people have a right to a clean and healthy environment? That has had some early success. Specifically, and we have someone from Montana, I know, in the group, the case of Held versus the state of Montana tried this particular strategy. In 1972, when Montana's constitution was essentially reconstituted, there was language put into the Montana Constitution that said essentially that every Montanan has a right to a clean and healthy environment, and that the government of the state of Montana has to ensure that that right is upheld, which opened the door for this case where young people said the decisions to allow for a certain kind of opening up of fossil fuel exploration in our state under state policy violates this constitutional right that's in the Montana Constitution. And they won. Now, currently, it's gone to the state Supreme Court. It's still ongoing. But the hope is that this will actually be upheld. And in the long run, will establish precedent. What's really interesting about that, and I was going to see if I have in my notes, the other states that have this, but I don't know if I'm going to be able to tell you. There are about 8 states, Missouri, by the way, I don't think is one of them, that have language in their state constitutions that enshrines the right of those state citizens to have a clean and healthy environment. I think Rhode Island's one of them. I believe Pennsylvania is one of them. I think Hawaii is one of them. I think Illinois is one of them. I could send that later, or it'd be very easy to look up. There's been a lot of discussion about this. So will there be similar cases in those states, not just around climate change, but around other issues? If a state is violating that constitutional right, can the agency that approves that move be held accountable? What's really interesting now is there's a movement to push for ballot initiatives to change. Thank you, Ethan, for putting that out there. Hawaii, Illinois, Massachusetts, Montana, New York, Pennsylvania, Rhode Island, and New Mexico. So if you're not in one of those states, one of the things that's happening here in Ohio is there's a group of people that are saying, well, let's push this through via a ballot initiative. If we have been able to push through reproductive rights in the context of the most recent kind of political changes that have happened, and I'm not assuming any political allegiance here or that everyone has to agree. It's more just that the strategy may be adopted that's similar to that to pass a change via referendum to the Constitution, which is what we can do in Ohio, to enshrine that right, which may lead to the ability to better protect the environment. Really interesting strategy, and we'll see how in the long run it holds up. There is also a case, I should note, Genesis versus EPA, that is also, once again, trying to make the case at the federal level that young people are being deprived of their life, liberty, and properties, which is protected in the Fifth and 14th Amendments. And whether those constitutional claims will be upheld, we will see. But here's where we are. And I remember, I'll bring this to kind of a conclusion by talking about the plastic story. I remember as this was happening, I was writing about it, I was teaching about it, and I thought it was all very interesting. But I thought, if this is happening for climate change, will it happen for like the plastics industry or other industries? Will similar arguments about nuisance and public trust and constitutional claims be brought against the plastics industry? And I was thinking about this in the context of a document that I wanted to flag for everyone here. If you haven't seen it yet, it's worth checking out. This was the Center for Climate Integrity's kind of plastics expose report they put out recently to try and show what the plastics industry knew about the recyclability of plastics back in the 70s and 80s when plastics became this kind of explosion. You can think, for those who are a little bit older in the audience, of Dustin Hoffman in the movie The Graduate, when of course he's coached by his neighbors, I guess a father figure who says, plastics, it's the future, and that's coming in the late 1960s. In that moment, what did they know about the recyclability of plastics? What did they tell the public? And do the two coincide? And so this report is really worth going through on your own time. You can go find it at the Center for Climate Integrity. Davis Allen is an environmental historian who got his PhD from Case Western University in Ohio, and Dana has just put that report in the kindly in the chat, and it'll show you documents that are currently being used in litigation. I'm kind of showing my hand here, that are very similar to what I just played out for you in the climate change space. Documents like this one, which they took really a long time. I remember being in on the conversations with the team about finding these documents. These go back decades to show what the plastics industry knew and what, in context, what they were telling the public at the same time. Here you can see a solid waste fact sheet. This is created by the Vinyl Institute, of course, vinyl being one of the big plastics of the time. And you can see here, nevertheless, recycling cannot be considered a permanent solid waste solution, as it merely prolongs the time until an item is disposed of. And why is this significant? I'm not going to be able to show you all these other documents that at the same time, they're arguing to the public, don't worry about this. This stuff will find a place in this recycling system. Even the symbol itself, we recall, is this kind of circular economy. There will be no waste. This stuff will end up being reused in a kind of perpetual loop. Internally, these are the things that they're talking about. Recycling cannot be considered a permanent solid waste solution. This is as late as 1986, by the way, because some people say, well, recycling was so new in the 70s. Well, by 86, we have curbside recycling. We have a lot of improvement in it. And they're very clear that it won't be. They found handwritten documents in the archives, many of which were very difficult to acquire. Here's one, notes from a November 1995 American Plastics Council meeting. And this is a staff meeting where they reveal clear knowledge that recycled plastic is not economically competitive, which remains the case for many of the recycled plastics we have. Here's a note that says virgin supplies will go up sharply in the near future and kick the shit out of PCR prices. That's recycled plastics. That was not only, spot on, but it remains spot on for many years to come. You could argue that PET won, and some of these plastics has found a little bit more of a market in some cases. But for the most part, they were right about the economics of much of this. This one was probably one of the more damning ones. This is a note from the American Plastics Council meeting in January in 1994, and they're quoting a executive of Exxon Chemical who said, "We're committed to the activities, that is, to putting out recycling infrastructure, to building recycling, but not committed to the results." In other words, we want to, this is kind of classic greenwashing here, right? In so many words, we will make it look like we're going to be building this recycling infrastructure, but we're not committed to the results. Partially because they understood that the results were going to be near impossible to achieve, a kind of true loop of recycling all that plastic. This is a document I found for 1976. I remember finding it when I was writing my dissertation almost 2 decades ago in Virginia. It was the FDA, which actually did an environmental impact statement on plastic bottles for carbonated beverages and other beverages, including beer, which really didn't take off for a variety of reasons, but carbonated beverages, was a big market. And the FDA, under NEPA, which we talked about earlier, was required to assess the environmental impact of plastic bottles. That impact statement was very, very clear. Pepsi, Coca-Cola was invited to comment. They did. The FDA took those comments into consideration. They reassessed their technical assessments, and they came back with this ultimate conclusion in 1976, saying that our final environmental impact statement concludes that substantial recycling of plastics is unlikely in the near future, either for plastic or for energy, that is to say, for burning plastic as energy, as an energy source, primarily for technical reasons and lack of a market for non-virgin plastics. The final EIS notes that these problems do not exist for glass and metal containers. And so that leads me to this last moment that's really today. So this is where history ends, and I kind of have to sit back like the rest of you and wonder what's going to happen as we move forward. My job is not to tell you that these cases will be successful or that we're going to see this new dawn of kind of corporate accountability. What I am going to tell you is that this is a new day under the sun when it comes to legal strategies being deployed and the types of cases we're seeing emerging. Those docs you just saw are the very kinds of docs that are being used in these cases to say that these companies knowingly put out products knowing that the recycling would not actually reclaim most of it, though telling the public that it would, creating, as public nuisance law says, a public nuisance that harmed the citizens of California. And one can imagine if these cases spread to other states as well, to other places. Now, ExxonMobil has actually sued the Attorney General for making misstatements. They say he's made misstatements about them. They countersued, essentially. It's a rare situation, actually, where ExxonMobil is suing the Attorney General about misstatements, supposed misstatements he's made about their deception in a case that's about ExxonMobil's deception. So stay tuned, because I think these cases will be remarkably interesting as they unfold. But is this a strategy that could lead to real punitive outcomes for these businesses? We'll have to wait and see. That's precisely what they're asking for. They're asking for, massive compensation that would actually be committed and then used to potentially clean up some of these plastic problems moving forward. But whether that will happen, again, I can't predict. How did I do? I'm at 8:18, and like I usually do in my classes, I like to stop early. Hopefully that's early, so that we can have time for Q&A and discussion. I appreciate your time. This is the end of the day for me here, and I've tried my best to give you everything I can, but I've certainly left a lot out of the story. So hopefully, if you have questions, please feel free to drop them in the chat, and we can have a real conversation. But thank you for your time, and look forward to hearing from you.
So Bart, you can probably see the Q&A. We do have a few questions in it. I wanted to briefly mention something that you made me think of in regards to the cases that have been brought, particularly by youth, saying that whatever activities of fossil fuel companies have infringed on their rights, right, to life, liberty, and the pursuit of happiness, their health, etc. Right after that Montana case, we started seeing proposed bills in Missouri that were kind of similar. They weren't exactly the same, but um, bills that would disallow anyone from bringing a claim about the rights of nature or an ecosystem or representing any sort of like non-human natural system and the damages that were being imparted on those systems. So
Wow.
it's
Was that in Missouri?
it was, yeah.
Mhm.
It was in late 2020, so our
Wow.
2021 session. So kind of right after Montana, and I just was curious if it seems related.
Oh, totally. And I think, one of the things we have found, because I've actually, obviously been, one can imagine as a historian, I've been, in the conversations here in Ohio as people try and push for legislate, or I shouldn't say legislation, but a constitutional amendment that would sanction this. The issue is not so much a counter measure that would block that as much as it is just the sheer enormity of trying to get this bill or get this constitutional amendment through, um, as a ballot initiative. And just the scale of the money, we were told on the order of, tens of millions of dollars. Um, and yet, I know of specific organizations that, again, right now on the late of the eve, I can't remember the name, that are there to assist states and people in states that are trying to push for these types of things. It has made, I think, folks in Ohio consider whether we have enough purple in our blood to push through such a move through the actual legislature. A lot of people would say there's no way, given kind of the way that things have been shaken out in Ohio recently. But these are tall orders. Whether you're facing, again, a measure that's trying to block it, which I wouldn't be surprised. It's interesting to hear about what's happening in Missouri. But just even getting these things through legislatures or getting them through, um, a ballot initiative is really, really hard. The only thing I'd say about that, though, is that you kind of get people on record. I mean, if you look at Montana's language, it's about as innocuous as it gets. You know, everyone has a right to a clean and healthy environment. And I think even having a unsuccessful campaign at least gets people on the record saying, no, I do not want to support the fact that every person in my state should have a right to a clean and healthy environment. It's kind of like, at least we know, what we're talking about here. So we'll see what happens. Um, Jack, I see today the Supreme Court rejected a big bid by Big Oil to toss Honolulu's climate suit. I have no other thoughts, Jack, about that because I'm not following it very closely, though. Hopefully, I'll be in Honolulu at some point. Who wouldn't want to be uh, just enjoying the wonders that is the Honolulu? Um, other than to say that we're seeing this in several states, where Massachusetts, for example, um, there are ongoing cases that are not being um, thrown out. And so, at the very least, companies are having to kind of pay attention and spend some resources on this. And to the extent that we'll see these things move forward and be successful, we'll just have to wait and see. Anonymous attendee has said, what is the quality of those 1,760 climate related cases? If you talk to attorneys like I have that have been in these cases, they will tell you they've ranged widely in terms of quality. For example, I was talking with the attorney who had worked on the Kivalani case where Exxon was successful, and he said that he wants to like the Juliana case, and I'm not a lawyer, but he would say he just doesn't see. He sees it as more of a kind of splash and awe kind of case, and doesn't see um, perhaps the briefs being as strong as they could be. So I think it really varies. And if you do have a legal background, I really think you would have a field day going through that Sabin Center case law just to kind of look at the various cases that are in there. Some are much stronger than others. And you can look at all the briefs. It's amazing. They have PDFs of everything, the original complaint, the appeals. So you can really follow the case and understand the ins and outs of it, which can be helpful if you're going to go on your own campaigns.
Hey Bart, I want to like piggyback a sec off of kind of the second question on that, which is like about the strength. Do some of them simply reflect the litigious nature of the US? And when you were presenting about how relatively few cases there are in other countries, like I kind of had that same question, or is it because there is less abdication of duty by legislatures, executive branch, whatever the
I think
executive
it's
branch is
certainly the
called there?
latter, right? That's what's driving it. I think there's no doubt we're a litigious society. I should say, in the interest of full disclosure, my dad's an attorney, so it's one of the reasons I got interested in this is because, and from a very young age, I was always talking about the law and recognizing its real power. So I think there's a little bit of all of this in the story. We certainly are a nation that is litigious. I do think the particular moment is no doubt people were frustrated about the inability to get things through Congress or their own state legislatures. And I think that's one of the reasons we've seen this escalation. The question is how effective they're going to be. Again, people that I've run into at COP, for example, that are professionals in the space, are leaving their positions to go work in this space because they really believe there's an opportunity here to really move the dial. I think NEPA, for example, is a very powerful means. We might think of NEPA as like, it's kind of wonky. It's not as sexy, the right word, probably not, as constitutional law, say, oh, we're going to win this big thing about you have a Fifth Amendment right to this. But it may be more effective, because that statutory law is very clear. You need to assess all the environmental impacts here. And if you don't do that, you're in violation of NEPA. So I think that's what's to kind of fully answer that really good question. I think sometimes these laws that may seem less, I don't know, cool, for lack of a better word, may be the best strategies. And in some senses have been. But to just be clear, the NEPA cases have been successful. They have forced the various administrations to actually kind of say, okay, we need to rethink this. We need to go back and do an impact statement. That's slightly more holistic. Is it okay if I just keep going on some of these questions here? Let's see. Some state legislature ignore or undo the results of ballot initiatives if they don't align with the majority of the state house. What then? That's just the nature of the beast, isn't it? And I think it's one of the things we talk a lot about here in Ohio is, we don't want to waste resources on something that's not going to be effective. My sense is, again, just getting people on the record, especially when these amendments are so simple, opposing something like that, it kind of finally gets that out that like, okay, we're clear on this, right? It's this issue of wanting to protect the environment that we're not willing to do. The reason I think that's interesting is if you go back to the 90s and the early 1980s and even late 1980s, even when Reagan is leaving and Bush is coming in, look at some of the legislation. The Republicans were still supporting environmental legislation in those spaces. The idea that this is a far right issue to not like the environment or not support environmental legislation and it's a left cause just wasn't the case. There's a really great book. Some people are saying, well, then what happened? How did we get to a point where these things became so partisan? There's a great book called The Republican Reversal. And it's by two scholars, Drew Eisenberg and Jay Turner, who are the leading environmental historians that trace that really pivot moment. They look at the 92, 93. It's actually in that moment with John Sununu inside the Bush administration. Remember, Bush signs the Rio Earth Summit agreement. He's also not signing the Convention on Biological Diversity. So there's a little bit of a mixed record. But you begin to see that shift, and they really trace it out in that book of like what happened and how the issue of environmental legislation became kind of synonymous with red tape and big government, and how that kind of language was really weaponized in some ways. in ways that made an otherwise party that had supported things like the Wilderness Act. I mean, Republicans were one of the biggest backers of the Wilderness Act of 1965 to where we are now. It's a really good education on kind of how we got there, which I think is one of the things we have to do. We have to figure out how to unpack that moving forward. Municipal waste collection also misled people. Our company was doing single stream recycling, but they were shipping it to China, and our plastics ended up in the Pacific. And it's a huge issue too. And to the extent that waste management companies will start appearing in these suits, I wouldn't be surprised at all. Just to give you the extent of what types of companies are being included in these types of cases, in the case of climate change, McKinsey, like the consulting firm, is now a named defendant in a climate change litigation case. You know, mind blown when you think about the history of this litigation, which started with kind of fairly, obvious suspects, and now consulting firms are being included. What does that mean? If they're successful, if McKinsey gives advice to, say, your municipal waste collection company, Christine, that you're talking about, that leads to an adverse outcome, though they have documentation that shows that they had a probable reasonability to know that that was going to be the outcome, but they gave that advice anyways. Does that change the way that consulting works? Does that give people a little bit more of a kind of moral hazard there of thinking, okay, wait a minute, should we give this advice? It's not really moral hazard, it's more like kind of CYA. Do they actually give better advice as a result? Be really interesting to see. Steve, how concerning to you, and what are the possible near-term ramifications to some apparent shifting of authority from science-driven federal agencies to what appears to be partisan judge court decisions as it relates to legal issues? It's a major concern. I think it's one of the reasons why this shift in administrations has been problematic for some, because of the appointment of judges that seem to be very antagonistic to the science behind climate change. And I think you're right to note that there's kind of a confluence here of shifting to the courts right at the same time that you're having these appointments that may very well be adverse to establishing the kinds of precedents that plaintiffs want to establish. So much unknown as we move forward, Steve. So really a great point to make. I'm looking to see if anything came up in the webinar chat, and Dana, maybe you can help me too, because there's a lot of things coming in over there.
It looks like someone else also commented on how recyclable materials are bought and end up being shipped to poor countries and dumped in communities. Then these, including clothing, eventually gets washed out to sea. I mean, that kind of goes back to the other question that was in the Q&A, and there's lots and lots and lots and lots of information on this topic.
Yes, and there just I mean, it's an endless conversation, because the issue is not simply can you can you collect the plastic bottle. It's can you actually reclaim it and reuse it again. And that involves the point that many are making, which is that a lot of this waste ends up going to countries where there's a kind of a very rudimentary form of recycling that leads to a lot of toxic exposures and very extreme adverse health outcomes as a result. And it's particularly bad in terms of things that's not just plastics but electronics recycling. Of course, it's probably all familiar to many people here, and it's an issue even for me. I have two kids, and I think for a long time we were being pitched that we should use these kind of green trucks, for example, the kind of green recycling, plastic kids' toys and things like that. When tested, many of those recycled materials, of course, have contaminants that can be problematic. And so this idea of buying a green product because you want to be a sustainable parent that has this green plastic thing for your kid, is its own kind of greenwashing, in part because of the process of how this all works. I think an untold story is not even about the recycling that happens overseas. if you haven't been to a recycling center in modern times, it really would be worth your while to go to see what goes on in these spaces. In Atlanta, I think there's a huge human rights issue that's not being told about recycling, which is the story of the workers that are in those spaces. The air quality is actually about as bad as it can get, partially because of the single stream that someone noted earlier. You have all these cross contaminants. And when I was in reporting on this back in the 20 teens, no one was wearing PPE. This was long before COVID. Many of the workers were actually former inmates, some of the most vulnerable members of Atlanta society who were just trying to get a job. And we left as a film crew, we were documenting this for a documentary film, just hacking up gray matter out of our lungs because of the atmospheric, the kind of the contamination in the air. So I think this green system that we created needs a slightly closer look at the labor that undergirds it and the impacts that we're having on actual people's health in these spaces. Just reading and to the extent that there are things, Dana, that you have as well. I'll see. You know, at COP, I'll say that one of the things that we experienced was we talked to a lot of senior vice presidents of sustainability at some of the bigger companies. And there was a very candid, I won't out them, the specific people, because I think they were trying to raise the alarm. But I think in part because of the administrative shift in the United States, and let's be honest, a rightward shift in politics more broadly on the environmental front, there's been a real kind of like going back on promises that corporations have made on these kind of recycling commitments and so forth and so on. One that was really startling, of course, it just came out from Coca-Cola, or not startling, but just kind of par for the course, was Coke going back on its promise to reclaim every bottle that they put out to the environment by 2030. And what's funny about that is I remember at the time, NPR had asked me what my thoughts were on the ability for them to meet that target. This was back, like, I think in the late 20 teens. And I said, I don't see them having any plan to effectively do that. And history has kind of proven me right here, because they have just said, as of like a month or two ago, that they're going to now commit to 70% by 2030. Now, whether that will be met is another thing. So, but that was the tone at COP. A lot of folks inside that space were saying companies are really pulling back, and in many cases on the promises they're making. And I, kind of left me with a little bit of a bitter taste in my mouth.
And what's really interesting is there's like a worldwide public outcry on this topic. People don't, whether they know about all the processes or know about the things that you've spoken of tonight, or that folks in the audience have put in the chat or in the Q&A about where does this actually go. No one likes this amount of plastic, even if all they see is the waste end of it, not even the workers' rights and like things that you've talked about as well, or even the production aspect, it being fossil fuel. But amongst this world outcry, and in some countries, strides being made towards reduction in actual plastic volume, corporations are like, yeah, well, that's like cute that you guys think this is bad, but we're just gonna keep on doing what we're doing. And that's pretty remarkable.
Which is why I think the litigation strategy is at least something, because the point is that, if these start to work, then it's one strategy to say no. you know, you can't say one thing. And frankly, this is why I think environmental history matters. These documents are really hard to get. In fact, there's a very famous archive called the Hagley Museum in Delaware, which is often used by folks in the business history kind of space that I'm in. And it's actually DuPont. It's an archive that DuPont put together with their money. And surprisingly, they had some pretty, damning documents in it, including a plastics folder that just went disappearing as a lot of this kind of sleuthing was going on. And the archivist was approached and said, kind of like, what happened? And they basically said, look, the plastics industry came in and took this folder out of the archive. That's all we have to say. It's their documents technically. So, we didn't have any right to keep it, I guess. But as these documents start emerging, and that's the other thing I'd say about these cases, is simply discovery. even if some of these are not successful, getting to the stage of discovery where new documents emerge, where we can see people saying, we know X, but we're going to do Y. Perhaps that leads to more effective lawsuits in the future. Could any of this litigation address the problems of microplastics and the health issues that results? There is a lawyer who I will not, again, I try not to name folks in these situations, in part because I know they're doing really hard work at a time where, they're under a lot of pressure, including from the very businesses that we're talking about. And I, by myself, having written about Monsanto and other companies, have experienced this. And so I don't want to jeopardize their work in any way, but I will just say that, yes, there is a very specific kind of a line of approach that's trying to suggest, if we can think about microplastics and have an ability, a traceability. If you remember, that was one of the biggest issues with proving impact, was making sure that we could say this is the company that had that impact. If we know that a certain type of plastic, for example, is largely produced by X company, could there be ways to create cases that make a human health claim about impact that could be more effective in the courts? Now, even as I say that, Kim and Jeff, I can think of all the problems with that type of litigation, because it's very difficult to make those connections. But I will say, maybe going back to Dana, that one of the most impressive things is that people have been able to establish standing. That the courts have upheld this idea that young people have standing in these types of cases because of the claim that their lives will be impacted by this. That is its own kind of precedent that is important. And Massachusetts and versus EPA, why could Massachusetts have standing in that case? Because it has coastline. And they made a really cool argument. It says, look, we've got X coastline. It's being affected by climate change. Here's the amount of land that's now being affected by it. And the courts bought it. So we're seeing some progress on terms of like precedents being set. Whether that'll change the game, we'll see. I have to be just slightly attentive. I've told Dana this. I have a high school student in California that is waiting for me for a podcast. And because I was a high school teacher, students always get precedence over anything else I'm doing. So I may have to jump in just a second, but if there's any final thoughts or questions, we'll see if I can answer them. Dana, I don't know if there's anything kind of coming in that really jumps out to you. I'm just going to tell the student as we're waiting to just pause for a second. I'm coming.
I think that there's a general thread throughout this where people are like, we just need to keep up what we're doing right now and keep sharing this information and keep empowering people with it. Those of you that are new to the plastic space, Dana is quite a leader in it. And she's helped host about 12 different webinars on our YouTube channel that address the topic and take you down those deep dives. Put a link there in the chat. So just do a search on our YouTube channel for plastics and you'll get into it.
And I think that's the same I would say to everyone, that we're dead serious at Ohio State. If there are things that you're interested in and you're interested in these kind of questions, there's a bunch of historians here that we kind of think of ourselves as almost a think tank, who are here to make history matter and to help people as they think through these kind of really tricky problems of accountability. And I think documents matter. I found that to be true in my own career, that the right documents can really force change. Doesn't always work, but I do think history matters. And so I hope folks will reach out if you're struggling with something that we could be helpful with.
Bart, thank you so much.
Thank you all. This was really great.
Thank
fun.
And now that it's the end of your day, it's time to do a podcast for California.
Yeah, there we go.
There you go.
Thanks everybody for attending.
Yep.
Yes, thank you, everybody. I hope to hear from some folks, but we'll see you on the flip side.